We spoke earlier about assets that would pass pursuant to a will. How about assets that don't pass pursuant to a will? Life insurance policies, retirement accounts, property held with rights of survivorship. In our litigation practice, we often see cases where beneficiary designations are not changed after a divorce, and down the road, someone who will be claimed not to be entitled to money gets money, or someone who is obligated to get insurance doesn't get that insurance. Can any of you speak to how you deal with those issues? Because I think what I see as part of the risk is that the client, although told, you got to change your beneficiary form, you got to deal with this, as with many other things, it sort of falls by the wayside.
Yeah, that's a good point. I think a lot of clients are just so wiped out emotionally by the divorce litigation process that when the paperwork is signed, they just take a back seat for a while and they let loose ends kind of go by the wayside. So I think it's real important as part of our practice that we make sure to revisit those concepts real quickly. I have not seen a situation where a beneficiary has not been changed and somebody passed away, so I can't speak to that, but it is an important part of our practice that we make sure that those beneficiary designations do get changed.
The general rule that we see is something that is a payout by contract, such as an insurance policy. If the beneficiary isn't changed, then it's going to the ex-spouse. There's been a little bit of case law exceptions if part of a settlement includes a very broad and yet very specific disclaimer on such interests, where there was a case, Lowry v. Fensel in 2015, where the court sort of covered up for someone. He hadn't changed some designations on retirement accounts, and they sort of saved his estate and ruled that the former spouse had effectively waived the interest in those accounts. That was a particular case with good language in a settlement. The general rule is you will lose out. I recently had a client whose former husband did not change a life insurance policy that he was entitled to change. That was a windfall for my former client. But the former spouse who passed away, he had plans elsewhere and they didn't get followed through on.
We have seen several claims against estates that relate to things that should have happened during divorce. And I can think of two examples. One is client comes, her father had passed away. She's now in her 30s, but dad had never paid the college expenses that he was contractually required to pay under the divorce decree. And now she wants to come and sue his estate for those payments. Second thing I've seen is a father who was required to keep a life insurance policy naming his children as a beneficiary. He never established it. He never set it up. The children now are suing his estate. Do you see things like this happening? And is there any statute of limitations that you're aware of that would prevent claims against estates for things that may have happened or didn't happen pursuant to a divorce decree that can be 10, 20, 30 years old?
I'm actually going to put the statute of limitations back on y'all, since you are the folks who end up litigating those claims. We're on the front end. The danger for a divorce settlement agreement is, as you say, it may be 10 or 20 or 30 years later that folks come out and say, oh, we didn't realize we had to address that issue. And one of the biggest paranoia points is the concern of, how do I know he's going to pay the premium? How do I know that the beneficiaries aren't going to be changed? We can put language in that makes a court requirement to provide on an annual basis, or if we really want to be pesky and nosy, try to get semi-annual, quarterly, a statement from the insurance showing that it's in force and that the beneficiary designations are as they're supposed to be. Your remedy, if the person hasn't done it, is to go to court, which people don't want to do, on a contempt of court claim. But that is an issue that is important. We try and put in as strong a language as we can that would say, if the person who's required to have this insurance policy fails to do so, then the other party would have a claim against the estate. And we'll put that right in the settlement agreement so it becomes an order of the court against the estate for those amounts.
Does this kind of go against the concept, though, you talked about at the beginning, where you say if these two people don't get along and we want them to be divorced, we want them to be divorced financially. So maybe it's not a great idea to have ongoing financial obligations that keep them tied together.
Where we will see insurance policies will be during the time that there is some other financial obligation to cover the amount of child support. So if you're getting divorced and there's another 6 or 8 years of child support until the kids finish up high school, that would be the length of time that life insurance might be required. Similar for an alimony, although the law is more favorable to a requirement for life insurance to back up child support, there is no requirement for that for alimony, although sometimes it's something that would get negotiated. But no, for lifelong, just simply, hey, I'm your ex-spouse, and if something happens to you, I want to get $1 million. No, that would, in fact, I've had people who specifically have said, I don't want my ex-spouse to have a financial interest in me dying.